All right, well, good morning, everyone. Good to see all you erstwhile ladies and gentlemen here of the bar and of the police and of, all kinds of different organizations represented here today, and everybody has an interest, hopefully, in this particular topic. We're a little late getting started. We have some members that are obviously absent, a couple of them, but I think we're going to move ahead, and hopefully we'll be able to move through this pretty quickly. For those of you who haven't been here before, let's introduce the members of the committee that are here. And Nikki Randall is over here. She's our erstwhile. Are you still a caucus? Okay. Okay. Well, Nikki's been a great friend for a long while, a good legislator, and she's here to honor us with her presence. I have Chairman Golick here on my right, and Vice Chairman Powell on my left. And we'll be the ones that will hopefully be entertaining your thoughts today. Why don't I start with just a word of prayer today to get a little guidance going. Lord, thank you so much for this day. We praise you for it. Thank you for the wonderful Thanksgiving. Let's praise you for the opportunity to operate here today in the wisdom and knowledge that you've provided. We ask your blessing upon this meeting now. All those participate may be honorable to you, and we pray this in Jesus' name. Amen. Amen. Okay, first up, what we're going to do is, last time we got together, we talked about things that were not related to reclassification. And so those issues that are related to reclassification are going to start second. We're going to work through some of the things that we talked about last week. And what we did, or not last week, but last meeting, and what we did was to get together and discuss and ask Terry Long, our legislative counsel, to help us kind of formulate some of the thoughts that we had into some things that have a legal connotation to them. So she put them in the form of a draft bill. Now, for all those of you out there who want the copy of the draft bill, well, it's really not going to be available to you, because that's exactly what it is. It's really something for thought-provoking views for the committee that we'll take into consideration and then go back and revamp and see what recommendations we might make out of this committee for those issues. Terry, for the members of the committee, I'm going to direct you to the bill, the draft bill that Terry put together. Else, yeah. Okay. So what you have in front of you has a couple lines cut off each page. That wouldn't be good, since the ones that are at the bottom of the page are underscored. So. So she's trying to get that done right now. Okay. All right. How about an audible at the line of scrimmage? We're going to audible over to the reclassification area, and we'll wait for that to come back. I think it's important to have the right stuff to discuss. We'll get to that later on. Mike Kikera from the Administrative Office of Courts is going to present to us today some of the data findings that were done in the reclassification effort that was chartered through your ad hoc committee, basically. And so, for the purposes of the committee, we had asked, when Chairman Golick and I met with him some time ago, that there be data gathered from these types of reclassification citations as to how they were handled and how many of them were handled at the various court levels, and the whole raft of court data, effectively, that you've looked at. And you're going to explain that to us in much better capability than I've just done. But hopefully this will give us an idea of sizing the issues that we're talking about here in terms of reclassification. So with that, Mike, give us your best presentation. Hopefully that thing's working right for you, and you'll okay. All right, Mike. All right.
like to thank the committee for inviting us today. I work, like you said, for the Administrative Office of the Courts, and at the behest of the Chief Justice and actually Chairman Golick, we've been working very hard to take a look at misdemeanor traffic reform. And we started out, I think, a year ago when the Special Counsel on Criminal Justice Reform, in its report, recommended taking a look at reclassifying low-level traffic misdemeanors as civil offenses. And that, in fact, was the starting point. We've moved quite far past that over the last year, and particularly since the legislative session. I would like to thank the Chief Justice, who is not here today, but also all of the judges, the prosecutors, the stakeholders who have worked with us in sort of a loose, ad hoc fashion to take a hard look at what the impact of our misdemeanor traffic offenses are on the citizens of Georgia, on the court system, and on the stakeholders like local governments. Particularly GMA and ACCG have been very helpful and very interested in this project. What I've done is up on the wall is a copy of a presentation deck that I prepared for the committee. I put that up there so people can follow along. I promise I will not read from it and try and go through as quickly as possible to leave time for any questions. I will also point out that there will be a panel of judges and prosecutors who are the real experts on traffic offenses and how they move through the courts that will follow me. So this is, I think, a very high-level look to give the size and scope of what we are trying to address when we're talking about minor traffic offenses. Again, the Special Counsel on Criminal Justice Reform mentions misdemeanor traffic offenses and reclassification in its report, but it did not study it. There have been a lot of studies, a lot of discussion about minor traffic offenses, and the question is, one of the first things that we're asked is, why are you doing this? Is there a problem? And I would point out that some people say there is, and people may not be able to read, but there are a number of studies saying that there is a big problem, that these cases, these minor traffic cases, clog the systems. That's national. The Georgia Association of Criminal Defense Lawyers point out that it's a drain on resources that could be reallocated to more serious offenses. The Southern Center for Human Rights also issued a report recently focusing on, I think, probation, but some of that overlaps into misdemeanor traffic offenses, because many people who are found guilty or plead to having committed a minor traffic offense are put on probation while they're paying off their fines, or whether they're doing their community service. So there is an overlap there as well. The size of what we're talking about. Again, the presentation deck will show you that over the last few years we're holding steady at over 2 million offenses that are filed with the courts every year. And again, this is probably a slightly low number because we don't have all the municipal courts participating in this case count. But this is from the case count that the Administrative Office of the Courts does every year. So 2 million offenses every year in Georgia. That's a sizable number of people, cases that are moving through the courts each year. You can see that the municipal courts handle the bulk of them, but the state courts, probate courts, have a sizable share as well. I would note that there is not a state court in every county, and in those counties where there is not a state court, the probate courts handle traffic matters. What does this mean for local governments? This information is from Court Tracks, which is provided by the Georgia Superior Court Clerks Cooperative Authority. We're looking at about $550 million collected in the courts this year. This is not all traffic, but a lot of it is. So we're talking hundreds of millions of dollars that flow to local governments, that flow to the state treasury, that flow to designated funds each year as a result of misdemeanor cases and felony cases. But again, a substantial portion of this is traffic. So it's big business, and it's important as a stable and consistent portion of the revenue that local governments in the state get every year. So it's one of the questions that often comes up in this is, what is the revenue effect? The revenue effect could be quite great if this is not done correctly. I prepared a slide for the representatives on the logic behind traffic reform. I wouldn't say that everyone agrees with this. What I would say is that this is the reason why people think we need to examine it. There are, without an incarceration penalty, certain constitutional protections can't be invoked, and that's the right to counsel. What we're talking about there is the right to a public defender if you can't afford a lawyer, or the right to a jury trial, which in Georgia means for courts like the municipal courts and the probate courts that cannot hold jury trials, if a defendant invokes their right to a jury trial, that case must be transferred to a state or superior court in that county. Again, the logic would be that the resources of courts, prosecutors, and public defenders could be better allocated to more serious offenses, and that court administrative processes could be streamlined because you're not working through the administrative process of doing the transfers, moving the cases. Through the study, we also have talked at length about alternatives to incarceration. Incarceration is an expensive penalty for local governments when you're imposing jail time on somebody. If they've failed to pay a $50 fine, it really doesn't warrant the cost to a local government of something like $47 a day in jail time. So you're cutting off your nose to spite your face if you have to revoke somebody's probation or put them in jail because they have not paid their fine. We've also talked a lot about how the treatment of offenders varies from court to court. Determinations of whether somebody is indigent or does not have the ability to pay a fine, sometimes that's left to private probation companies who discover while they're executing their duties that somebody simply does not have the ability to pay, and they may have to allow them to do community service in lieu of payment of a fine. There's also fine schedules that vary from city to city. Some courts allow a grace period for people to pay their fines. Some people require that people pay their fines before they walk out of the courthouse or be placed on probation. The ad hoc group that's worked together, we have no formal decision-making process, but what we've tried to do is work through consensus. As a preliminary look, I posted the recommendations that we, I think, agree on. One is, as a first step, to eliminate the possibility of incarceration for the most minor traffic offenses, which is non-moving violations. I would say headlight, taillight. There's a pedestrian soliciting a ride on the side of the road is another one. But again, offenses that judges and prosecutors don't think warrant, in, I'd say, most cases, any jail time, which at this point is up to a year in jail. Another consensus recommendation is that the courts need more options to allow them to collect fines and fees. There's been a lot of talk, and I think a lot of favorable comment on the tax intercept proposal. Many people are interested in efforts to encourage courts to offer online payment options to make it easier and to give people incentives to dispose of their cases and to pay their fines. There's other statutes that currently allow reducing the fines to a judgment, which may affect someone's credit report. Again, the idea behind these proposals is to use positive and negative incentives for people to resolve their fines and fees, to dispose of their case as needed. The courts themselves are also looking at ways to update and streamline their processes to better serve citizens and improve court administration. There's been considerable discussion among some courts about training and best practices, so that there's a lot of things that through this study I think the courts have found that they can do to better serve the citizens of Georgia that wouldn't require action by the legislature, but nonetheless they see as warranted. The question presented to us at the last meeting was, what does the data show? The Administrative Office of the Courts has contracted with Applied Research Services, Dr. John Spear, who's well known as an expert on criminal justice statistics and analysis in the state of Georgia. We have now successfully collected data from the City of Atlanta Municipal Court, the State Court of Douglas County, and the Probate Court of Dooley County. The idea being that we wanted to have one of each court and courts from that vary in size and shape to be able to develop a model of what they look like, and from that to extrapolate what the impact of traffic offense reform could be across the state. Applied Research Services has converted most of the data now into a format that it can use. We have some preliminary information that I will show you on the next slide that really says, what are we looking at? At the first swipe, what do we see as the pain points for court administration, for local governments? And one of the things that has struck us is that even though in some jurisdictions, and I would say the State Court of Douglas County is one of them where bindovers is not a problem, bindovers or transfers between courts is a pain point for larger jurisdictions. One judge, who is Judge Robert Rodatus, who is the former chief judge of the Recorder's Court of Gwinnett County, said he strongly supports moving misdemeanor traffic offenses to infraction or fine only because of his experience that many defendants invoke the right to a jury trial as a tactical maneuver, not that they feel that they need their day in court, but they want to delay or postpone their day in court. I think I've heard there's a term that's thrown around, which is court shopping, judge shopping, prosecutor shopping, people who think that they'll get a better deal if they can remove their case from one court to a busier court. If you look at, for instance, the superior courts, if there's no state court, the case would have to transfer from probate or municipal court to superior court. And the superior court judges, they're busy with felonies, divorces, a lot of things that are considered more serious matters, and they actually have a priority list, and it's very difficult to get. And again, I'm generalizing from court to court, but there can be very significant delays in resolving a case if it has to be moved to a higher court. What I show on this slide is an example from the City of Atlanta Municipal Court, where if you look on the far right side, there's a highlighted number which is 1485, but it doesn't quite jibe, but it's very close to the minimum number of transfers that we saw in 2010 from the City Court of Atlanta. 1,500, and those would be individuals and not cases, requested that their cases be bound over to State Court of Fulton County. That's a lot of people, that's a lot of administrative time, and you can see under the column that says months that bindovers add a layer of time, not just having to start fresh in a new court, but that the originating court, which is the City Court of Atlanta, it actually takes them longer than an average case to send the transfer over. So what you're seeing is not only is it creating more work for the new court, but that it actually delays the work that needs to be done in the originating court. This is something that we're looking into to try and provide a statewide assessment. Again, preliminary indications are that the larger courts have a bigger problem with this, where the tactical use of invoking the right to jury trial causes problems and adds significant delay and cost to the courts. Another thing that strikes us is how many people actually take responsibility for their offenses. Through a mechanism called bond forfeiture, offenders can pay their fines before they are arraigned to resolve their case. What happens is they pay a bond amount that is equal to the fines and fees that they would owe. They then do not appear at arraignment, and then the court takes and forfeits that bond in payment of the judgment. So, and that actually, we find, even though it may not happen before arraignment, but before trial, in Douglas County, I believe it was 84% of people take responsibility for the case by either pleading guilty, pleading nolo, or using the bond forfeiture mechanism to pay their fines and fees before a judge, before we start heading to pretrial and trial. So 84%. We have a lot of people who will, in Georgia, who will own up or simply say, you know, it's not worth the hassle. But this is a very efficient mechanism for resolving cases, and it's one reason that Georgia's courts can process these millions of citations every year. Again, this is something else we are going to examine, because really the main question is, what type of sanction do we need to punish and to deter, and to actually punish and deter these offenses, but also to get people to pay their fines and to satisfy the judgments of the court. What we're seeing is that there's probably a very small percentage of people who have the ability to pay and are simply unwilling. Again, we are moving very steadily to try and match up the data collection and analysis with the recommendations. Certainly, what we want is the data analysis to inform the recommendations that come from the stakeholders that we've been working with. We want the analysis to reflect the concerns and the questions that people have. And in fact, we are very interested in the discussion today because that will also inform us how we move forward in terms of analyzing the data and providing meaningful results to the community that's interested, and also to the Title 40 Study Committee and the legislature. Our intention is to conclude the work and provide what will essentially be a final report by your next meeting in December.
Okay. Mike, thank you. Appreciate that. Appreciate all the work on this of the members of your group. Questions from the committee for Mike? Okay, let me get you turned on here. Chairman Gold.
Thank you, Mr. Chairman. Mr. Coccaro, this subject matter really came to the fore during the session, actually as a result of the preliminary recommendation of the Criminal Justice Reform Council last year.
Yes.
It was part of their set of recommendations. There were no real specifics in it. It's my secondhand understanding that the real driver on that, regardless of who it came from on the council, that doesn't matter, but the real driver on that, at least preliminarily, were from certain Superior Court judges in jurisdictions that don't have state court. We've discussed this here before at one of the previous meetings, who were uncomfortable with the idea that they were having to deal with jury trials on red light cases or whatever, on moving violations, when they should properly be spending their time and resource and the public resource on murder and mayhem, domestic relations, whatever else comes in their door. And that goes for the DAs involved and the public defenders as well. So we had discussed previously, what's the mechanism that we can set up, if necessary statutorily, to get that out from under the Superior Court saddle. I've not heard from the Council of Superior Court Judges directly at all, so I'm asking you the question. Has the working group that AOC has convened, have y'all come up with a consensus, not that you've had to by this date, don't get me wrong, but have you, or is it your intention to come up with a consensus proposal to address that specific issue on Superior Courts, trying moving violation jury trials?
Well, first of all, I am not aware of any position by the Council of Superior Court Judges itself.
Me neither.
I talked to the General Counsel an hour ago.
Okay.
What I can say is that past president of the Council of Superior Court Judges, John Pridgeon. Speaking for himself, he presides in a jurisdiction that, a smaller jurisdiction that doesn't have a lot of misdemeanor cases, but periodically he will have a traffic case that comes up to him. It's not necessarily that he's uncomfortable that a minor case is before him. What is troubling to him is that, again, with the felonies and the divorces and
It's time.
yeah, is they're stale when they get to him. And it's very difficult, I think, for the prosecutors to prosecute at that point. It's difficult for the jurors to understand why they are, you know, up to years down the road hearing about a red light, or even in some cases, one of the things we unearthed is people asking for jury trials on seatbelt cases, which they wouldn't normally receive one because there is no incarceration time for a seatbelt offense. So I think that what the other councils are looking at with non-moving violations and things like that, that they take a significant cut at the most minor offenses, and in that way at least partially address what Judge Pridgeon was talking about. So,
Would it be their intention then to recommend that those sentences be less than 6 months in order to avoid the jury trial, right?
well,
In order to avoid the public defender costs and all?
Well,
Is that where you're going with that?
there's a couple of issues. And again, I would like the judges to
Sure.
help me with this.
Sure.
Certainly they'll be participating later. But the focus has been on two tiers, or two new tiers of offenses. One would be fine-only offenses, so zeroing out the incarceration time, which we know would not have, somebody who is accused of a fine-only offense would not have an automatic right to a jury trial and to a public defender if they were indigent. That's clear. What's less clear is whether a 6-month incarceration time would be beneficial. Again, I think I've looked at it, the judges have looked at it, and there's, I think, a real difference of opinion as to whether the Georgia Constitution says that petty offenses are not subject to the right to jury trial, petty being 6 months or less, or whether a jury trial is required in all cases where there is a incarceration sanction. So that's, again, on our slide earlier, that's why I have it gray, and that is still being debated. Whether there would be a right to jury trial with those 6-month offenses. The other reasons why you might want to have a 6-month offense is because that's what the severity of the offense merits in terms of public safety and deterrence. So there are other reasons, but the focus has been on whether or not the 6 months would provide that savings or that reallocation where court resources, prosecutors' resources, public defenders' resources could be allocated to more serious offenses.
And if I recall correctly from the previous meeting, it's not like we're looking statistically at some giant mountain, load of cases that that fall into that category. My understanding is it's just the opposite. That doesn't mean that that it shouldn't be looked at on the merits. Is this the highest and best use of that public resource? These Superior Court judges trying red light cases in areas where there's no state court.
Mm-hmm.
So I guess I want to go back to my first questions to make sure I've got clarity. And if the judges need to go ahead, when the judges need to go ahead and address that directly, that's fine. Is it your sense that there's a consensus proposal or consensus potential solution on that particular issue from your working group, or no?
I would say that the consensus would partially take care of that problem that you've heard about from the Superior Court judges. Mm. It won't solve it totally. But again, in our last meeting with the Chief Justice and the stakeholders, the look at the non-moving offenses and the possibility of some 6-month tier is also looked at as a first step. The idea being that we truly take the lowest level offenses, change them to fine only, and see what the effect is, and then analyze that to see if there's a reason, number one, to expand that to other traffic offenses that are not simply, window tint or taillight out, but also see whether it is instructive to us about the way the way offenses are punished in Georgia generally. Right now, the General Assembly has really used three options. You have the civil penalties, like for seatbelts, or the traffic cameras. You have a misdemeanor, which is generally 12 months or a $1,000 fine, and then you have felonies. Would it be beneficial to the people of Georgia if the General Assembly had a larger array of tools for better tailoring the severity of offenses? And that's, I think, something that could come out of continued study, sort of a pilot of the non-moving violations. You could see what the effect would be on deterrence, whether we have people still adhering to judgments and paying their fines, that sort of thing.
And that goes directly to the issue of where do you draw that line?
And again, that's what the proposal is to start small, and I think most of the stakeholders agree, start with a finite set and then look to, if the data warrants it, to expand in future years. Another thing I would bring up is there is some what I would call out-of-the-box thinking or creative thinking among the judges. One thing that I think a couple of the councils have hit upon in their statements and in their discussions is whether superior courts can invite judges from other classes of court who handle traffic cases routinely to sit in their court to help them move the minor traffic cases. That's one idea. There's another idea of how the different classes of courts can work together as courts that have overlapping traffic jurisdiction to resolve matters within their county without the need for legislation and using the discretion that they have.
Well, that, I mean, I appreciate the indulgence, Mr. Chairman, but I mean, that goes right to the issue of right now, superior court judges can designate a state court judge or any other judge, I think, as an assisting, I'm not sure about that, but I think as an assisting superior court judge for a time certain for the year. So if Judge Pridgeon can go ahead and designate, if, and it's an if, can Judge Pridgeon, just as an example that you brought up, can designate his local probate judge or local magistrate as an assisting superior court judge to handle that jury trial red light case that he doesn't want to handle, then what's the issue? Then is there an issue?
Well, that's a question I would reserve to the judges.
Well, let's hold on. I mean,
Yeah.
We'll get to you.
Judge Jackson, let's just go ahead and, since you're over there and he's over there, let's, okay. Thank you, Mr. Chairman. Appreciate the time and the indulgence.
Any other questions for Mike? Okay, I've got a couple myself.
Yes, sir.
The just going to a couple of these points on the bind over issue.
Yes.
That slide you had. I'm having trouble understanding what. I understand the months disposed in municipal court and those that are bound over in terms of that time. I don't know what this total means. It doesn't seem to add up to anything.
No, that's what the total is an average. It's not added. It's an average. So
based upon the number of cases, I mean, it's not an average of 2.7 and 3.4, obviously.
Well, it's a weighted average based on
That's
how many
right.
are bound
cases.
over versus
Okay.
how many are disposed of in municipal court. I'll tell you what we think this means. Disposed of in municipal court means that the case has ended, however, whether it's been null prost, whether it's been withdrawn, dismissed, somebody's paid their fine, but it's resolution in the municipal court. The average is 2.76 months. For a case where the right to jury trial has been invoked, the time it takes from when it's filed in municipal court to when it leaves the municipal court is almost 3.5 months. So what you've done is you've extended the life of the case in municipal court a month, and you haven't done anything to resolve it.
Okay.
And so you're basically starting fresh in Fulton State Court.
All right. Couple other things that occurred to me. I was going to say, on these reportable funds page,
Yes, sir.
they say they're not all traffic, obviously. I mean, do you have any idea what this really means? Because part of this issue has been the sizing of this in terms of what the nature problem is. And the other part of that is, if you did reclassification, what would it do to these numbers?
Right, and that's one of the things that we expect to show using the test sites, the 3 courts that we're studying, is to look at what the size, if we're talking about non-moving violations, well, let's look at how much money is generated in each of those courts through fines on those offenses. So we could say that if a court brings in, say, well, let's say $100,000 worth of fines are imposed, then there'll be probably on top of that another 100,000 or so add-ons and surcharges.
Right.
So the question is, of that group, if you are changing, let's say half, because I'm really using some rough numbers.
I understand.
But if you're changing half of those to incarceration only, how much of the money would you be putting in play in terms of questions of, are people going to pay? Are they going to feel they don't have to pay based on the fact that there would be no jail time? So,
well, I mean, that's, as I understand it from sitting with you erstwhile people a while ago and hearing your first testimony, that's one of the major issues in terms of, the dependency on the funds to run the
yes.
court. And this is a lot of dollars. The other question that really comes out of this is of the 1.3, 1.4 municipal court minor traffic
Yes.
offense filings. Is there any feeling for, if you did a Tier 1 reclassification, how many of those would effectively fall under the Tier 1?
I do have, taking a look at using the state court proposal, which lists out a number of offenses that they think, if we go down this road, they might consider for as no incarceration penalty. And I've looked at, I have some numbers from the City of Atlanta right now, and some of those non-moving violations are among the top 30, 35 cases in terms types of cases in terms of volume. I could probably pull together a number for you fairly, in 10 minutes or so, a rough number, but off the top of my head, I would say that it's maybe 10%. If you're
So 10% of the 1.4 million?
No, City of Atlanta, so 10%.
Oh, so, I'm sorry.
Yeah.
Okay, I got it.
So, and again, the City of Atlanta is unique in the size and the sheer volume of cases that it has. So I have to say that in some respects it's unique.
Yeah.
But we have seen that in terms of the case types that they see, the offenses that they see, it's fairly similar to Fulton County or the Douglas County State Court. But what I would say is that we would be looking at affecting, and again it's rough, but 10, maybe 12-15% of the case volume in the City of Atlanta Municipal Court. But again, and the further cut on that would be, okay, well, how many of those are bound over, or jury trials, or again, what we need to do is follow up with your question and then ask, okay, how are these processed and disposed of?
Yeah. Yeah. Again, I think if we represent this by the proposal, in other words, if there's a municipal court proposal for a Tier 1 to do so and so and so forth, it would be valuable to understand what we're talking about in terms of what this is going to do. Because if you implement, a civil penalty effectively that goes to the idea of tax refund, we're going to intercept the tax refund for the amount of the fine, fine and fees. This could be an incredibly big volume issue. I mean, just to implement this at the Department of Revenue to do this might be some significant time constraint and cost.
Well, I think
to get that done.
I know Judge Jackson and Skin Edge, who's here, I think they've been working through how that might work with ACCG. One of the things would be to, if somebody has an unpaid fine, is to actually set up the mechanisms with Department of Revenue within the courts, but to actually, charge a fee. If the court has to go out and collect it from you, well, maybe there's another additional $5 that's tacked on
right.
That's taken away from your refund to offset the cost to revenue. And again, I'm not as deeply involved in that portion, but I think there is the expectation that there would be a cost to set it up and to begin to administer it, but that there is a benefit to that.
I guess you also indicate in here that alternatives to incarceration or available enforcement judgment fine imposed by the court include making it easier to pay the fine, license suspension, tax intercept, and reducing unpaid fines of judgment that will affect the individual's credit ratings. I continue to be concerned about license suspensions and the relative effectiveness on that. You push on one side of the marshmallow for a license suspension, you get more drivers that drive without a license effectively,
yes.
and therefore uninsured. So, I'm not sure. And I know that the volume of these offenses have been going down over the last 4 years, but I don't know if that's just enforcement or, it's actually less people driving without a license. I don't think that's probably the case.
I have to say, we have paid a lot of attention to the question of license suspension and the fact that it can spiral. You get your license suspended, and then you're caught driving on a suspended license, so they suspend your license some more, and
it's a never-ending cycle, isn't it?
Right. So if we had found a silver bullet, we would have let you know.
Okay. All right. I think I had another question here.
Yeah. But again, that's part of the idea of trying to find additional incentives. And again, it's not just negative incentives, not just sanctions, but to make it easier to pay, help explain the process to people better so they feel like they've got better customer service and are less resistant to taking responsibility for their offense.
On your last page, where the Douglas County
Yes.
Case resolution, it said 84% own up and just pay.
Not just pay. It's either plead guilty, plead nolo contendere, or dispose of their case through bond forfeiture.
Yeah, but the point was that 84% of them handle it in an expeditious manner, I guess, is
Yes.
what we're saying, right?
Yes.
In other words, from a court time standpoint, it's kind of nil. Now, here's my problem with the data, I think. I mean, going to this idea of what was that page where we had the averages? Oh, here it is. The average time. What was it?
It's
Case disposition time.
Yes.
So what we're really talking about here, if I get this correct, and if Douglas County is any example, the 84% of the cases don't appear in the 2.7 number that are disposed to the municipal court, right?
Okay. Well,
I mean, they're probably in the number, but in other words, they don't take any time. There's no court time involved necessarily, right? There's administrative time, but there may not be any court time.
Right. Well, the arraignment will take a judge's time.
Okay.
But, again, the question is, are you gearing up for pretrial, or actually having a trial,
Right.
whether it be a bench trial or a jury trial?
Right.
So, again,
I guess what I'm saying is, what this data tells me is that if Douglas County is representative of the state, and 84% look like this, where they're virtually processed perfunctorily, I guess
Yes.
I would say, then my guess is that the 16% that's left over heavily contribute to this 2.7, 3.4 in the time that's allocated to this. And so the question is, which ones on this list really affect the time and resources of the court?
We're looking at ways to use the numbers. One of the things we're doing is taking a number of different data points. GMA did a survey of municipal court clerks that we've been looking at. ARS has got this data. We have state-level data that's collected by the Administrative Office of the Courts every year. One of the data points that we're looking at using is in the caseload studies that are done on superior courts. They have weighted averages of how long it takes for a superior court to process a case. And again, it's only useful to an extent because it's an average. But the average misdemeanor in a superior court is considered to take 13.17 minutes. And again, some of these, again, the processing is different. But when you're talking about a case, an average misdemeanor case being resolved in 13 minutes, but you've got to still continue to understand the spectrum of processing time, if there's a transfer involved, whether there's a trial, or whether it's bond forfeiture. So there's some extremes that we'd like to get into.
Let me ask you, just for clarity, the grayed out lines on this chart, are they the resolutions that represent the 84%?
Yes, sir.
Okay. Yeah, questions on the data, or have we exhausted this topic? We exhausted Mike for now. I mean,
well, I won't be sleeping much the next 2 weeks while we continue to crunch the data and really delve down into what it means for Georgia.
I think that, as we talked, I think the significance of this is what's the involvement of the time and resources based upon the reclassification that may be proposed, and what kind of dollars are we talking about in terms of what we're affecting?
Right. I don't have data on this, but I was talking with one Superior Court clerk a couple of weeks ago at the COAG, or Constitutional Officers Association of Georgia meetings, and was talking to him about the reclassification proposals, and he remarked that he didn't like the transfers because it cost him more in administration than he got in fines. So.
And therein lies the rub.
Yes, sir.
Okay.
I'd like to thank you and the rest of the committee for your...
All right. Hold
Oh,
on.
I'm
No,
sorry.
Stand by.
I've got it.
Stand.
Representative Powell?
What number is 20? Okay. Chairman Powell.
Mike, I've got one request, and I look down on about the third page, and there's something that still keeps going back. It sort of rubs me the wrong way, even though it is a very true fact, as we're dealing with the just system of justice. The statement, government relies on fines and fees as a major and a consistent source of revenue. I mean, we all know that's the truth.
Yes,
we
sir.
all know that that's the reason that in some jurisdictions that they have speed traps, or they have, and law enforcement gets branded. Just simply, I got a request that I'd like, since we're talking about money, to sort of give us a broader picture. I haven't seen in recent years a update about dollars that are being raised on all these, on the secondary part of the fine.
The add-ons and surcharges?
All the add-ons,
Yes.
all the surcharges, all those wonderful things that have funded various and sundry retirement funds, annuities, and each and everything. Do y'all have some current information?
I have the 2012 figures in my bag. Be happy to give them to you.
Is there some way that you could make that available with a complete list of all of the surcharges and the dollar amounts?
It's available online through the Georgia Superior Court Clerks Cooperative Authority. They have a website called Court Tracks that has all of that information. Actually, my consolidated reports for 2012 came from there, as did the information that's contained here. But it does go into how much money goes to the spinal injury, or the brain and spinal injury trust funds, retirement funds, things like that. But I will give you today the consolidated 2012 report that lists that.
On that list, does it have accumulation in each one of those funds that are basically parked in those accounts?
No. It's just simply the money that was reported or remitted to those funds. So I can't, for instance, I can't tell you how much is there. I do know that, at least in the case of one fund, they're very concerned that those, and I think it's the Spinal Injury Trust Fund, they're very concerned that the revenues have fallen off so dramatically that they may not be able to continue to fund, provide the services and the grants that they have been doing.
The reason I ask, I don't know, I mean, it's been years since we had discussed this in some of the committees that I'd served on. Back years ago, there was a lot of discussion about the cumulative total of these amounts. That some of these amounts that went to some of the different funds, that there was such an over amount of money that had accumulated in these, such as some retirement funds, was that if you had taken every one of the particular elected official that was covered under that, if you took every one and then future and whatever's left, it didn't never come close to even using that amount of money, something that maybe needs to be looked at from the knowledge of these, of the legislators. But is there any way of getting that to see when there's been a recent audit of those amounts and actuarial report maybe looked at?
I can look into that for you. I think we would have to look at the administrator, look to the administrators of those accounts, or whether Department of Audits has done a recent audit. But that's doable, yes.
And my rationale to that is that since we're all we're doing here, we're talking about money. We're talking about how to make the process more streamlined, and hopefully at the end of the day of making something that makes more sense to the public, that would probably, hopefully, will raise the level of respect for the officers out there that are having to enforce these laws.
Well,
Thank you.
Again, I think the impetus, in talking with the Chief Justice and the judges and the stakeholders, I mean, the revenue is a concern because if you do something drastic, you're going to adversely impact the citizens. But the question is, can we do better by the citizens of Georgia, by the people who come through the courts? And that's what the recommendations will be geared to, and not certainly to. I haven't heard anybody say we want to enhance revenue. They want to protect, I think, the consistent revenue stream because, again, if you do something, especially in this environment, that's too disruptive, you impact many other things besides just traffic offenses. But I will get you the preliminary information today.
If we get talking, taking a good look at it, we'll probably fill this room up 3 times more.
I think we have something like 22 different add-ons and surcharges, so yes, there's a lot of skin in the game there.
Thank you.
Mike, thank you. I don't see any other questions, so we thank you for the work so far, and we're looking forward to seeing what you conclude on some of these issues in terms of the things we've discussed already today.
Well, we appreciate your interest and attention. It's, the numbers show that this impacts our citizens, and we're glad that you're taking such a serious look.
We are, thank you, Mike. We are going to do another audible here in terms of, no, it's okay. We're going to do another audible. We're going to hold the other than the reclassification issues and decriminalization issues, we're going to hold the other issues we're going to talk about that were the first thing on the agenda. We're going to hold that to the end since I think we got a thought process going here, and I'd like to kind of keep on moving on the reclassification issue unless there's any objection to that in the committee. So the next item here is a discussion from the panel of judges. I think, Mike, is the way we set this up.
And prosecutors and solicitor, President of the Solicitors Association.
Okay. All right. Well, you guys come on up here and join us. Make yourselves comfortable. And once again, this feels like deja vu all over again, you know? You can pass those. There's a couple microphones there. You can pass them back and forth between you, I think. I don't know. Or you can come up to the one up there. That's fine. Well, though we've got your names here and everything, why don't we just go and introduce ourselves one more time here.
All right, I'm David Darden. I am president of the Council of State Court Judges. I'm from Cobb County.
I'm Chuck Spahas. I'm the executive director of the Prosecuting Attorneys Council.
Good morning. Stephanie Woodard, President, Solicitor General's Association.
I'm Jay Stalter with the Council of Probate Court Judges. I'm from Cook County.
Okay. All right.
Jay Stalter.
Jay Stalter. So, Gary, why aren't you with them?
We just have a slight technical problem. I'm sitting in for Judge Whitten, and just sent a message. Like they're just unsynced themselves. Senator Edge is going to get that for me. I'm going to sit in for Judge Whitten, President of the Municipal Council.
Okay. All right. Well, that's fine. It's good to have you all here today, and I know you've been working diligently on this, and having seen you at work in that little committee room that gets pretty hot, I'm surprised there aren't some misdemeanor offenses committed in there.
Contemplate.
But I know you're all working, trying and form some sort of a policy that we can look at and make some decisions on based upon good data that you're already working on and the considerations of each one of the organizations that are represented. So you guys have forwarded reports of where you stand, and for committee's purposes, you'll find them in your packet. So why don't we, Judge Darden, why don't we go first with you? I think I started on the left before. Well, we'll save Judge Jackson for the. Let's go down the line. Cleanup.
Okay.
There you go. Okay.
Well, we have talked about this a lot. We've it's not only obviously the various councils of courts, but prosecutors and that sort of thing. And we've the councils of courts have sort of come up with proposals. And rather than walk you through that, I'm going to answer whatever questions you have. I just have a few points I want to bring up, and they sort of spin off where Mike started. We have been trying to get a handle on where this is coming from, or where the desire or the impetus for reform comes from. And real quickly, the issue of superior courts handling these minor traffic offense jury trials is not a big issue, really. We've raised an early proposal that, as Chairman Golick talked about, that there are local solutions at the courthouse for that, using assistants, judges by assistants. I don't share Judge Jackson's fear that would leave probate court empty in a detrimental way, because there aren't a lot of these cases, as you've seen, that make their way to superior court. You could ask a probate judge or a state court judge to come over and assist and clear the traffic calendar of minor traffic offenses that have made their way up to superior court, a couple of days a month in most counties. And I'm not speaking for City of Atlanta, but it would not be a terrible thing. And of course, Judge Daughtry may have more to say about that. And of course, we've talked about, and we are working on the issue of circuit-wide state courts. We've got several counties that are interested in doing that, which would allow more counties that do not have a state court to share the expense of a state court and get these cases handled through jury trial issues. I would say one of the things that we say the logic behind traffic reform is the elimination of incarceration will not significantly affect the deterrent effect. That's incomplete, and the reason it's incomplete is it doesn't address the role of probation. All right, probation does allow for deterrent effect. When I put a 19-year-old or a 21-year-old on probation who's had 5 speeding tickets, part of my probation is you can't have any speeding tickets while you're on probation, because it's going to be a problem. With fine only, they pay their fine and they move on to the next speeding case. So there is a role for probation. There is a deterrent role in probation, and I use it every day. I can't speak for the other judges, but when I use my sentence sheet, the box I check is, you cannot violate the law while you're on probation. Not only is that a new case, but we're going to come back and look at it in this case. So probation is very important. So I do think, and again, it depends on where you draw the line, but there can be an effect on the deterrent issue and on public safety, because we lose that deterrent effect if we do away with probation. Probation is sort of the other side of the coin of incarceration. The other thing is there aren't any metrics that I see on people who are incarcerated on minor traffic offenses, and that's the issue. That's the issue. It's one thing to say that they've gotten a sentence which has the potential for incarceration, but the reason in many cases, the reason it has the potential for incarceration is because it has the probation component. People come in front of me. I handle thousands and thousands of these cases. What people need is time to pay. And that's what probation provides for them, is time to pay. And that's, candidly, the reason behind a lot of the delay, Mr. Chairman, that you talked about with regard to continuances and continuances. It's not because they want a jury trial. It's because they want to try to arrange for taking responsibility for the case, but they're just not ready. They don't have the money yet. They need time. So I get people all the time, and I'll say, why did you ask for a jury trial on this red light case? They say, well, Judge, I ran the red light. I just needed time to get my fine payment together, and I ran out of continuances in municipal court, so I bound it over. I just need more time. And that's one side. That's pre-sentence. The other is post-sentence. People will say, I'm ready to take responsibility for the red light I ran. I just can't pay the ticket today. I need some time to get it paid. So those are sort of the realities of when we talk about fine only. There's some realities behind that we're going to impact. They have nothing to do with actually going to jail. They have to do with people who need time and the deterrent effect of probation. So we would lose some of that. And that's what I see every day. I don't put people in jail on red light cases. I don't know anybody that does. We're just trying to give them time to pay. And I guess when we talk about the draft legislation that you're looking at, I would hope that it would include a couple of things. First, the line would be very low, equipment violations, that type of thing. That's what I put in our proposal. Second, that it should address minor traffic offenses, if they're moving offenses, which are committed in conjunction with other more serious offenses. And the example I use is a failure to maintain lane while the driver is under the influence of alcohol. That failure to maintain lane should be addressed not as a fine-only offense. The punishment for that should be enhanced because the driver is also committing the offense of driving under the influence of alcohol. But if we say all failures to maintain a lane are fine only, we're not treating the situation that we should. We're not allowing the courts to have the flexibility that they need because not every case is the same. So I guess the other thing is I wouldn't want to create statutory restrictions which would limit judges to handle different cases, cases which need different treatment. They need to be treated differently. We talk about an average everyday citizen with an absolute clean driving history. We say, okay, well, we want to, with a statute, we want to address and have a lower fine or a fine only and that sort of thing. Well, what if that person, it's their sixth offense, and this time when they had a failure to maintain lane, they swerved across two lanes and caused a serious accident? If by statute we control on one end and restrict it, then we've tied the court's hands to deal with a case that is different. So that's a sort of a normal caution, I guess I would urge. One of the things that Mr. Gaccaro, his report says is that the treatment of offenders vary from court to court. I don't know about that. I only have one court. But I know that treatment of offenders vary from case to case, and that is the judicial system. That is our responsibility. We have to assess those cases in which this type of sentence needs to be entered or this type of sentence needs to be entered. So those are some big picture issues that we have. You have our proposal. We have proposed that there is a very low level tier that should be fine only, that we address this issue of infractions which occur in conjunction with more serious cases, and we've addressed the issue that we need to make sure that we leave the court's flexibility to treat cases differently when that is necessary. I'll say one other thing, and then I'll let these other folks speak. There is disagreement about the 6-month tier, and we're reasonable minds not only can differ, they do differ. We've discussed it, and we look at the law differently. I have some significant concerns, and we've discussed this in our meetings about, under the current state of the law, under the Supreme Court decisions that we've addressed and talked about, whether a 6-month tier would remove the right to a jury trial. There are a significant number, I guess, of judges who feel that under the state of the law now that it would not. And then from terms of social policy, if our social policy is to say to a driver who commits a minor traffic offense, driver A, clean history, never been in trouble, great driver, and if the idea under the 6-month tier is to create some sort of middle ground where we tell that driver you're not being branded as a misdemeanor, in reality, does that matter? I mean, if somebody says, well, we're not going to put you, you don't face 12 months in jail, you just face 6 months in jail, I don't think you've really established any social policy with that driver. They don't want to do 6 months either, obviously, and they're not going to. What you do when you shorten it down to 6 months is that person who is having difficulty paying the fine, you've just cut in half the amount of time that they're going to have the flexibility. You've just cut in half the deterrent effect of probation. And if it's a 6-month sentence and they need to go to, be treated or go to classes or have defensive driving, all of that now is compressed instead of in a period that you can handle over 12 months is now down to 6 months. And realistically speaking, I can't give somebody if there's a 6-month sentence, these judges will concur with this. If you give someone a 6-month sentence, you cannot give them 6 months to pay the fine. You can't give them 6 months to get treatment or go to defensive driving, because you have to have time for enforcement if they don't do it. You have to leave time to bring them back in and say, why didn't you go? Are you having money issues? You could do community service instead. So 6 months becomes 3 months. So those are real. That's the real issue in the court. So with that, I'll answer any questions that you have.
Questions for Judge Darden?
Very good.
No. You can't get off that either.
Oh, I was going to scoot the mic down.
No, these other gentlemen, ladies probably know more about this than I do. I guess what I've heard you say is probably pretty much what I heard you say last time, too, Drew. But it appears that you're saying that if the problem that we're all here about is the number of cases that are bound over to Superior Court, if that's the problem, and there is no state court, it goes back to Chairman Golick's question, genesis of the discussion to start with. I guess you're saying that the solution is not in legislation; it's in effectively just allowing some other mechanisms to take place, whether you bring up a magistrate or whatever you do to cure that. And what you're talking about, though, of the total cases, 2 million cases, you're talking about what, 10%? No, you're talking about 1%. I get my math right.
Look at Douglas County, it's 0%.
Yeah. Okay. All right. But I'm just looking at the numbers here. Right. And you got 24,000 out of 2 million cases, and so what we're talking about is, if my math is correct, I think it's 1%, is it not?
Right. Even at that level, and of course, Douglas County, the cumulative percentage that are handled before is 100%. This particular slice of data that they looked at in Douglas County, they didn't have any jury trials. So, and again, we're talking about specifically minor traffic offenses.
Okay. You're talking about Douglas County.
Yes,
I'm talking about the whole number here.
Right. And that is a statistic which, based on my role in the state courts, obviously we talk among ourselves a lot, we just don't try that many cases.
Well, I think they do make the caveat here that this includes misdemeanors, not just traffic.
Right, that's true. And
So,
I think when you slice it at minor traffic offenses, it's just not a significant issue. And the real fact is, when we talk about, okay, let's say we do go to trial on a minor traffic offense, red light or stop sign. I mean, I can bring the jury in. We try I do this on the infrequent cases that we have that. The jury's done by the middle of the afternoon. They get to the courtroom at 10. They try the case. The police officer testifies. The defendant may testify, may not testify. We charge the jury. They deliberate. And so even that's the worst case scenario, that it actually does go to trial. It's just not a big detriment to the efficiency or the operations of the court.
yeah, what you're saying is those 24,000 cases are basically men's and men's, I guess, is what you're talking about in terms of the amount of time and resource it takes to
If
to
worst case
manage to
scenario,
it.
it does go to trial, we get it resolved. We move on.
Okay, that's some other thoughts here. It appears that that probation is a deterrent. From what I'm just summarizing what you said, is a deterrent, and that you seem to feel that is significant in being able to change behavior.
It can be, and that's what I was talking about, case-by-case method. There are cases where we need that probation to be able to say, this case is still alive based on your future behavior.
So, so moving. I'm just trying to think this through here a little bit. If we let's just take one example. If we said, okay, what we're going to do is we're going to move ahead and we're going to recommend the idea that your tax return is going to have a depletion in terms of whether or not you get any money back. If we in fact adjudicate it that way, and that's how it's going to get. I'm just trying to think about that. I don't know mechanically how that would work. I mean, that could well work in favor of being able to extend the time that people have to pay.
Well, if it's a fine-only offense, we don't have time to do that because we don't have probation available. So, this person comes in and we say, we're going to give you 90 days to get this paid. Most of them get it paid, and if this is an absolute, I can't pay it, then we may say, okay, through community service. But if as of the day of sentencing, we don't have any probation time to work with, well, then we're going to intercept their tax refund at great expense.
Okay.
If they have one.
Yeah, if they have one, that's right. Yeah, right. Okay. Okay. What did you think about the other opportunity of affecting the credit rating, as it indicated in the document that Mike?
If they can't pay their fine, I don't want to generalize, but it may be a situation where people, if they absolutely can't pay the fine, their credit rating is not of a huge concern to them.
That probably is true.
I'm trying to be diplomatic, but
that's right. Well, I guess the question is, why'd you recommend this? Mike, go ahead.
It's consensus. It's collaborative.
That is directed not at people who are unable to pay, but those who are able to pay and unwilling.
Unwilling.
There is a segment of
yeah,
folks.
Right. And the question back to you guys, what are we talking about here? I mean, how do you size that? Is it worth addressing, I guess, is where I'm coming from. Yeah, that particular issue that you mentioned.
The segment of those who are able to
Yeah. Yeah, that's another data issue as far as I'm concerned.
The apparatus and processes of the courts are set up to deal with that small percentage who are unwilling and unable, but it affects everybody who goes through the process.
Okay.
The administrative apparatus and costs are there, spread across everybody as opposed to that small segment who won't take responsibility with it.
Okay. Okay. Chairman Goley?
Thank you, Mr. Chairman. Just on that previous point, just to clarify, credit rating is not about how much money you pay. It's about how you manage the money that you do make. Excuse me, it's not about how much money you make. It's how you manage the money that you do make. Plenty of examples of people who are outrageously wealthy, but have bad credit, as in people making very little but have outstanding credit ratings because they live within their means. So just to make sure that's clear. And Judge Darden, just on a point you made initially, and just for clarity's sake, I don't think if, and it's certainly an if, we were to go forward with any sort of reclassification, modest or otherwise, I think the point was well made in the previous meeting that if you had someone pulled, if law enforcement pulled over someone for failure to maintain lane or even an equipment violation, and there was a bag of cocaine on the, on the passenger seat, obviously that's incident to the charge that pulled them over in the first place, whether it's equipment or failure to maintain, moving or not moving. There would not be a contemplation, I think I speak for everyone here, there wouldn't be a contemplation that all of a sudden that would just throw that out the door. It would have to be, I think we'd be looking at it in terms of that extremely minor violation, and if it's just that violation in a vacuum, as opposed to having a situation where you've got a drug arrest incident to the failure to maintain or whatever it may be. So I mean,
that's one of the
that's
issues.
in our contemplation already. I think it always has been.
Right, and I think that also, we didn't mention it, but I think that becomes important with our DUI courts.
Sure. Oh yeah.
State court. We need that extra. We need that 12 months. There's a failure to maintain lane in a DUI. You can get 12 months for the DUI. We need the 12 months for the failure to maintain lane. It takes 24 months to get through DUI.
Right, but you can do that concurrently, correct?
Right, because yes, we can do it concurrently and consecutively.
Consecutively.
Right.
Right.
So
Sorry.
that would give us the 24 months.
Right, I meant to say consecutively, to give you that extra time, especially as it relates to accountability courts,
Exactly.
which was at the very,
Right. That's where all this.
That's where all this began.
We
So-
lose that DUI court. That's really important to be able
Yeah.
to give these folks time to get turned around.
Right, that's fully understood, but I appreciate you reinforcing the point. Thank you, Mr. Chairman.
Just to make sure we all understand what the position of the State Court Judge Association is, basically you're not in favor, or you don't find that there's enough value to making a change to warrant any change at this point in time in terms of the reclassification, decriminalization effort.
Generally speaking, that's true. But if there is something done, we've suggested where the line should be, and candidly, it's very low.
And do you have any feeling for where? And this goes back to the question with Mike, and that is that when you construct that low line, it's not the Tier 1 offenses that are in the municipal court presentation. It's lower than that effectively. And then the question goes back to you guys in terms of how many cases are actually disposed in that particular fashion,
Right.
and whether or not there's value in moving ahead with that.
I don't know those ones.
The other side of that would be is it a valid test case if you lower the line too much?
Right.
If that's where we're going with this, or that's a possibility where we're going with this. Okay. Anybody else got any questions for Judge Darden? Okay. All right. See, the further we go, the more you could indict yourself. Okay. Representative Powell, why don't you
Feel free to slide that mic back over. Would you repeat what you had said in answer to Chairman Golick? You said that the necessity of leaving multiple charges, say in the case of a DUI, say a lane change that was stacked on top of a DUI. Did I understand you to say it takes 24 months to do a DUI?
No. What I was talking about is just the accountability court. When folks go into the DUI court, the requirements that they undergo take more than 12 months. And that's why they're so successful. They're very comprehensive, very successful. So the DUI courts need some time for the folks who elect to go into DUI court. They need more time to make those, for the defendants, for the people who've been sentenced, for their rehabilitation to occur. So it's just in the case of accountability. And those usually involve more serious DUIs or the more folks who have 2 or 3 DUIs in a limited period of time.
So you're saying they would need the other charges to add to that?
To be able to, and that's that's beneficial. I know it sounds crazy, but that's beneficial to the people, the defendants who want and need to get into DUI court. They need the time to be able to get the treatment and the types of things that they're required to do under DUI court for primarily rehabilitation. They need that time for rehabilitation to be effective.
So would we not be better off if we changed the terms of, say, a DUI to extend those?
It's possible.
As opposed to, in the common world, I'm not an attorney, but out there in the real world, a lot of them refer to the word stacking charges.
Right, and that's a possibility. I think you could say a certain number of DUIs becomes high and aggravated, and the sentencing for that would be 24 months. And in that sense, probably could get the same effect. But we're dealing with what we
possibly
have.
on certain of the offenses of decriminalizing and making them civil, then maybe we need to look on the other side of changing specifically on certain effects. I mean,
that may well get, in terms of that accountability court problem, that may well get us the same resolution. It's true.
Second question from a comment you'd earlier made about the use of probation, because you have offenders who come in on minor moving violations, red light violations, stop sign violations. Do you really have people who can't pay a fine that need extra time on those type of offenses?
Every day.
Is that because those offenses met such a high fine?
Yeah. Not really, because on those offenses, I'm going to be honest with you, our prosecutors, they want to move those cases. And when that irate citizen says that fine is too high, most prosecutors are going to say, well, let's find it. We're going to compromise. We don't want to use court resources to keep this case going. They'll reach a consensus, so to speak, a negotiation about what the fine is going to be. And most of the time, those situations, the defendant's going to say, okay, I can pay that today, or I need time to get that paid. And so we allow them to do it. But yeah, every day.
For instance, red light violation, first offense. What kind of fine does that net out?
I don't answer that because I don't negotiate the pleas. The prosecutor would. But I would say we see, $100. And I will say this, when the fine is imposed, the defendant is made aware of the fact that a $100 fine is not $100. It's $200 because of the surcharges.
And if they're having problems paying that fine, and if you give them probation, which we all know private probation is to ensure that the fines get paid, but if they're having trouble paying those fines, and by the time you put them on probation and they're paying a private probation firm.
What I'll typically do is say, how long do you think it'll take you to pay this fine? They'll say 30 days. I'll say, well, let's say 60. And I'm not going to impose any probation fines until after 60 days. I'm just trying to give you some time to get it paid. I'm not unique in that. We'll say, well, a lot of times they'll say, I can't pay it today. I'm ready to plead guilty to it or ask for a no loan. We'll say, well, why don't we reset it for 30 days? Then you don't have to go on probation at all. It's fine with me. I mean, that whole part of it, I don't know any judges that get excited about trying to ramp up probation fees. We don't care about that. We're just, let's see if we can get the case resolved and with a trial or whatever. But if somebody says, I can't pay the $100 fine, then I'll say, well, how long will it take? They say 30. I usually give them twice what they ask for because I don't want them up against the line. They're trying to be solicitous of me by giving a low number. And then I'll say, we won't charge the supervisory fees until after that time. And they don't report to the probation officer. They just come in and get their fine paid over that time. So the short answer is local court practices can address that. And reasonable judging.
And the real problem is that not every jurisdiction is the same.
Right.
Some judges may love private probation for whatever reason. Thank you.
Okay, for the committee members, this is what the state court judge's recommendation is. It's in your folder, and the various potential fine-only offenses are listed here. And how'd you come up with this?
Well, we went through, we opened up TitleForty and went page by page, basically. There is one change on that. It's very minor. It's kind of wonkish. But instead of the committed with another misdemeanor, we talked about that would be a separate misdemeanor. That's not going to work because the officer on the side of the road, when he's writing the ticket, is not going to know whether it should be charged as a separate misdemeanor. So instead of making it a separate misdemeanor, we would just say the punishment would change for the same offense. That can be worked out.
Right. Okay. All right. Where's this one come from? Is this the municipal court?
I think that's
This is yours,
Right.
Judge? Okay. All right.
That looks like, we just looked at prosecutor's work.
Is this yours, Chuck?
It's the one that we helped put together.
I'm sorry.
Okay. Does anybody take responsibility for this? I didn't see any, there's no nomenclature on here to indicate where it came from. And I guess what I was trying to figure out was, what's the parallel between these two, or is there any parallel between the
We
overlap?
have-
Okay, you want to speak to that?
Chuck can talk.
All right.
We have the fewer fine only, and we have no middle tier. We have
Okay.
no 6-month tier.
Okay. All right. Well, Chuck, it's your opportunity to excel here.
Thank you, Mr. Chairman. While you're on that, what our goal there was is if this committee or the legislature is proposing to do something, what we did was a statute-by-statute evaluation of what we believed could be statutes that could be changed without having a dramatic effect on public safety and or interfere with the ability to prosecute. So it's not our position that that should happen. It's just our position that if something is going to happen, those are the statutes that we believe are the safer ones to go into. The Prosecuting Attorneys Council, of course, doesn't have a position on this. We've been here to help facilitate it, participate in the conversation, and raise any issues that we thought the prosecutors may have. Just quickly, a couple of things that I do feel we need to comment on. One of the reasons I think I'm here is I was one of the ones arguing the loudest last year when there was a quick push to decriminalize. And of course, the first time I came before this committee, we went through all the reasons behind the difficulty in the concept of decriminalization. So before I make this next comment, I want to make sure we stand firm on the fact that we don't believe that that is the direction we should go in. But we do believe that the position of whether or not any of this would be eliminating the right to a jury trial, we stand pretty strong behind the fact that the Georgia constitutional provision that says if it's a criminal case, you've got a right to a jury trial, that is more restrictive and provides more remedy than the U.S. Constitution or the U.S. cases of the Supreme Court that have drawn the line. So we are of the opinion that no matter what we do here, if we stay criminal, which we support that you have to stay criminal, we're not going to eliminate the jury trial. Now again, as the judge said, there's some differing opinion about that, but that's the position we take. We would have a very hard time supporting the argument that we've eliminated the jury trial. Moving past that, I will say this, based on our experience in evaluating this has brought to a head an issue that we believe has been there for quite some time, and it's the concept of circuit state courts. And what that means is having counties come together where there's not a state court, where there may not be enough work for a full-time state court judge or a full-time solicitor general in one county, but in combining several counties within one circuit, there would be enough. And what that does then is it allows you to have a full-time professional judge handling those cases, a full-time prosecutor prosecuting those cases, and then not only traffic offenses but other misdemeanors would then come off of the docket in Superior Court. So it would have a much broader effect than just affecting the impact of traffic, but it would include all misdemeanors. So we do support that concept. It would solve a lot of peripheral problems as well. And only other thing that I'll comment on is it has been the position of the prosecutors in state court for a while that there are certain offenses that a 24-month misdemeanor would be appropriate, and multiple DUIs is a perfect example of that, so that the concept of stacking charges, for lack of better description, would be eliminated. You would be in court on the offense that you're in court on. And so that is a good concept. I know we've discussed it for several years in Chairman Golick's committee in various capacities, and that there probably is a place for that. And the only other thing I thought I would say, Chairman Powell, about your comment on probation, I will say my experience is that as far as private probation goes, most of the counties where private probation is used for fine collection only, There's usually a tiered collection from the probation provider so that they do not pay as much as they do for a regular misdemeanor that they're being supervised. It's quite frankly just a collection fee to cover the charges of doing that. It's almost the interest for borrowing that money from the state. So that is contemplated in a lot of the private probation contracts. And I'll field any questions, but again, the DA's Association and the Prosecuting Attorneys Council are not here proposing that we change anything.
Okay. Thank you, Chuck. Is there any questions for Chuck, prosecuting attorneys? I kind of have to go and think for a bit, I think, before we get back to you on that,
Yes, sir.
Chuck. Thank you. Okay. I think that's clear. I don't have any questions on that. Thank you so much. Okay, we're going to go to Stephanie, all right, and talk to the solicitors, if you would.
Good morning, Chairman. Thank you. The Solicitor General Association joins in with the Prosecuting Attorneys and DA's Association in saying, basically, we don't stand in support of any specific proposal, but that there are a few areas that could absolutely warrant reclassification, where a second and 5 driving on suspended is high and aggravated, a second and 5 DUI is not. And there's no need to, there are some finite areas in Title 40 that could stand reclassification and making more appropriate across the board. In the aspect of reclassifying to civil penalty, if this committee finds that they absolutely want to move in that, the solicitors, we didn't bother a specific typewritten report because we think it should be equipment violations only. The bottom line is every moving violation warrants individual consideration for punishment that needs to end up in a gentleman or a woman in a robe. A accident that is involved from a roll-through stop sign violation that is someone who's familiar with a neighborhood, rolls through there, becomes desensitized to that traffic control device and rolls through, is very different than a teen who is daring each other and playing games and blasting through stop signs, resulting in an accident in my jurisdiction last weekend before the holiday that seriously injured a small child and a grandmother. That's something that a prosecutor needs to flesh out the facts. Prosecutor and defense attorney need to give those facts to the judge, and someone in a robe. Not something that needs to be able to be logged on and paid online or an administrative penalty only. It warrants individual consideration. What I want to do is give you an opportunity to ask questions in realities as opposed to the generics. I can tell you I went back to look at my jurisdiction. I've been Solicitor General since December of 2008. In that time period in state court, where there's only 6 jurors, not 12, that we have in, and those 6 jurors may serve on 3 cases in one day, as the judge from Cobb County indicated. We've had 2 jury trials on traffic violations, minor traffic violations only, in the 4 years I've been in office. And both of those were individual cases where they were demanding their right to jury trial, and there were other circumstances that led the prosecutors who worked for me or myself to make a decision that this case needed to be tried. We have unusual, often we call frequent flyer defendants in state court that are not necessarily the criminally minded felons and dangerous folks, but that are continually malfeasant with the law and cause problems. That if we bow to the, I'm just going to play chicken and wait till you blink, we end up with larger chronic problems. I have some freemen on the land that think the laws of the state of Georgia don't apply to them. And those are cases where I'll try it. I think it's worth the 2 hours to say, yes, you do have to abide by the laws of the state of Georgia. And it is ultimately something that it is minimal. In both of those cases, those cases were done. We started in the morning. We waited till after the more serious juries were picked, started at 10, we're done. The jurors didn't return on that case after lunch. And that's the reality. In 16 years that I've been doing this on prosecution and defense side, I've seen 1 defendant in 1 jurisdiction go to jail on a minor traffic offense. That's an aberration that, as I recall, resolved itself in the next election cycle and was symbolic of other problems. It is not a systemic whole. Your solicitors, your prosecutors are very well aware. And Chairman Powell, I want to speak to, I will tell you that I am very clear with my county commissioners, with folks that come to see me. Revenue generation is not my business. And all of my colleagues that are in the Solicitor General's Association feel that way 100%. I can tell you that probation, state court, and courts, municipal courts and probate courts that handle traffic problems, I think we're the original problem-solving court. My judges use probation to solve what are the root problems. We spoke specifically about licensure issues. Every single one of my judges will give a credit towards fines if they pay for the reinstatement of their license. They use probation as a time of accountability and following through and following up on that. If we get too efficient, the real problems are not addressed. If we make it payable only, they'll pay a nuisance fine to not address or avoid that nuisance fine, to not address the root problem. And probation often turns out to be relicensing, treatment for a significant underlying problem, or DDS classes that ultimately help all of public safety. And that is incredibly commonplace. We are also not in the business of probation fine payment. We exempt, we tier, we have compliance hearings to avoid exacerbating, adding insult to injury, basically. I did also want to speak to one issue we were talking about, license suspension. Let me tell you that the reality in practice is more people will reach back to solve a license suspension issue than will pay attention to a bench warrant. Because it's common knowledge, we don't extradite, we don't pay that money on a misdemeanor bench warrant. I have people come back from states far and wide to pay a fine where their license was suspended for failure to appear or other issues, because that trickles through the system and ultimately suspends their license through reciprocity wherever they're at, and they'll reach back to resolve that Georgia issue because of a license suspension where they would not a bench warrant. And in actuality, I deal with about 18% of what I call the snowball. The cycle keeps resuspending their licensing. And in our jurisdiction, my judges work with probation to peel back that onion and readdress reinstatement issues. And we have an incredibly responsive DDS that works with my prosecutors to help say, here, line up, explain, here are all their suspension issues, here's the time they'd need. Even have had cooperation with reinstatements that are decades old in helping us to resolve that in the time period of probation. So I'd happily answer any other. What I don't want are the myths and the extreme cases that end up being an object of public ridicule because they are such an extreme, being confused with what the reality of business in state court and misdemeanors are.
Any questions?
Thank you.
Wait a second. Stephanie, thank you. Really, thank you for giving us the benefit of your experience and what you see. I keep going back to this, and the 84% of the cases fall into these categories the day they're in to forfeit the bond or whatever they do, NOLO or whatever it might be. There's really nothing in there that, in other words, and we still don't know of the 84% here whether they would be in the reclassification effort anyway. I mean, there's no correlation to that data that I can see. So I'm just trying to figure out what you just said and the effect on the 84% of the cases. My guess is no effect, right?
That's right. And understand that the other 16%, checking my math right quick, yes.
That's good.
Often need that minimal court time for the ability to get a NOLO plea, which again requires the discernment of someone in a row to have the ability to get that plea, or for the request for some personal accommodation. That other 16% is not necessarily a jury trial. That's minimal court time as well.
And that's why you don't think reclassification will have significant effect. Well, that's kind of clear from your perspective. All right, let's get some other perspectives here and see what they might lead to. Chase, you want to talk to us about
Yes, sir, Mr.
probate
Chairman.
court?
Yes, sir, Mr. Chairman. Thank you, and thank you to members of the committee. The Council of Probate Court Judges have long felt that titleForty reform should be simple and practical. The system in which traffic courts operate in the state obviously vary from city to city and from county to county. Where you have urban courts obviously face different challenges than those of rural courts, and vice versa. Over the past few weeks, an extensive amount of research and thought have been poured into this topic, and I think one thing that we can all conclude on, or agree on rather, including my counsel, is that sweeping change is not needed. Any attempt to overhaul a system that is not in need of major repair, we feel would drastically affect public safety and the effectiveness of the judiciary. You know, in the state of Georgia, we do not repave miles and miles of highway just because of one pothole. That's not effective, that's not efficient. We feel the same analogy applies here. Potholes that we're facing on the titleForty highway can be fixed very easily and can be fixed locally. As state court judges have mentioned on more than one occasion, local control options are the best avenues with regards to the concerns we have with titleForty. In your more populated counties, we feel like you can look at more state courts, and in rural counties you can look at more prosecutors in the probate courts, which is a practice the probate courts have been instigating over the past decade with support from our local Superior Court judges and our local Board of Commissioners. You know, just for example, just this year I probably handled about 3,000 cases in my court, and I've had one demand for a jury trial on a DUI case. And we handle about 75 to 100 DUIs. We're an interstate county, so those are quite common compared to some of your more rural counties. Taking this into consideration, you know, we kind of agree with what the prosecutors and the solicitors have said along with the state court judges. We feel that if we look at any reforms, it should be equipment-only violations with a maximum fine of $1,000. We like the issues of it. We like the idea of, you know, community service options, obviously, for compliance on these, and any failure to comply would resort in suspension of a driver's license. However, you know, we are intrigued by the idea of the municipal court judge's idea of the tiered system with a 6-month sentence regarding that. However, we agree with Judge Darden that there appear to be some constitutional issues regarding that at this time, not to mention the possibility, and more or less I think the fear you may have from the public, general public, if you go to the general public and say, hey, there's a 6-month sentence on this, you could face 6 months in jail, however, you don't have a right to a jury trial. I'm not exactly sure how that's going to sit with members of the general public. You know, obviously we appreciate the hard work and dedication of all the invested stakeholders over the past few months in analyzing this issue. There's one thing for certain, this process has created a lot of communication among the various classification of the courts. It's obviously created a framework in which I think the judiciary can continue to capitalize on in future policy matters. That being said, our council feels that the best route for the public and for the courts and for the rest of the stakeholders is to encourage local control options by creating working groups on the local level of the various classification of courts, GMA, ACCG, your private probation companies, and determine what model best fits their needs while taking into account the public safety needs, the governmental needs, and judicial efficiency. You know, the Lapa Hall Circuit, you know, we're going to kind of steal Judge Darden's idea. We've talked with our Superior Court judges and our new district attorney, and we're going to look at having a traffic calendar after the first of the year. We're currently in the process of working out the logistics of that. We have a 5-county circuit with no state courts. Obviously, Cook County, my county, is an interstate county. Again, there's a lot of cases that generate from those. So that being said, if we can work out the logistics of that, myself and juvenile court judges are going to look at trying to run a traffic calendar through the Superior Court later next year. We also support the foundation of the current system as is, with the exception of making all equipment violations fine only. We feel like this addresses the issues that's been brought forth revolving the criminal nature of these offenses while still ensuring the safety of our citizens. Council of Probate Court judges firmly believe that these two items fill our potholes without repaving the highway, and we encourage support from the committee on that. So, Mr. Chairman, if y'all have any questions, I'd be glad to answer.
Thanks, Chase. I appreciate it. Chairman Golick, question.
Thank you. Refresh my recollection, probate court judges don't have to be lawyers statewide. Is that a correct statement?
Unless you're an Article 6 court, which that's a population. I believe the legislature moved that down to 92,000 this past year.
Okay, so less than 92,000, a probate court judge does not have to be a lawyer.
Yes, sir.
Okay. So what I think I heard you say, and going back to the Superior Court traffic issue, which was really the beginning of this, I think. What is the population of your county?
18,000.
Oh, okay. So are you an attorney?
No, sir, I'm not.
Okay. So, I mean, as a practical matter, you could not sit in Superior as an assisting Superior Court judge, obviously. I'm trying to find a way to where the inter-county solution in terms of state courts, where there are no state courts to deal with the traffic, and where you have a larger county, larger meaning more than 92,000, I guess, then the probate court could, assuming it has agreement with the Superior Court, sit and handle traffic jury trials to the extent that there are any. I'm sure that there are some.
Well, in kind of the research we've done, I think Judge Darden's done more research on this than I, and my Chief Judge, Dane Perkins, has also, that on your petty traffic offenses, on your moving violations, we're of the opinion the way that code section reads for judicial assistance, any judge could assist in that regard. So that's kind of why we are talking about looking at probates and magistrates possibly serving and presiding over that traffic calendar.
Oh, I see. So where's the divine? All right. So on what kind of charge?
Traffic only. So
traffic only.
When we're looking at it, we're still trying to get into the logistics of it.
Which goes to the issue of, well, what exactly does that mean?
Well, non-arrestable offenses.
Okay.
So basically, more than likely, we'd probably still let our DUIs and suspend the licenses, say on a regular misdemeanor calendar in Superior Court, and if you had a probate or a magistrate presiding over that traffic calendar, you'd be looking at more your non-arrestable offenses, in which, you know, the likelihood of a motion hearing or jury trial is zero.
And an example of that kind of charge would be, for the benefit of the committee?
86 miles an hour and 70 mile an hour zone. Speeding, running a stop sign. Yeah.
Okay. Because that provides a potential mechanism then for getting back to that issue of, well, handling those traffic cases where you don't have a state court.
Yeah, and one of the issues, you know, our Superior Court judges kind of had this foresight 4 or 5 years ago, where there was no prosecutors in the probate courts, there was no state courts. Clinch County actually had a state court, and they went back and dissolved that. So they were looking at some issues that, number one, benefited the taxpayer, something the county commissioners were agreeable on, because obviously funding state courts wasn't an option at the time based on revenue and things of that nature from their standpoint. So they looked at prosecutors in the probate courts, which had kind of been a practice, I believe, started in some municipal courts around the metropolitan area and have trickled around over the state. And since that time, that's been a big push by our council as well as some of our rural county commissioners.
So just to be clear, Mr. Chairman, what I'm hearing is that we can take a look at, and council can too, that there is an existence in law today that the probate court can in fact handle traffic.
You're talking about on a Superior Court level? Or you talking about, is the question, can a probate court judge handle traffic cases in a Superior Court? Or
No, not in a Superior Court, but in the probate court itself.
Yes, sir.
Okay.
Yes, sir. There's 83 counties in Georgia that, that have a probate court that has traffic jurisdiction.
Okay. I think I need to get a diagram.
Flow chart.
Sort of flow this out on certain counties that are certain populations and who's doing what, because then you're looking at, in all seriousness, then you can figure out what the most practical options are for what's best for that jurisdiction. But and then that just leads to the question of, all right, well, if that's the issue, what statutory change is necessary, if any, in order to make that happen?
Yeah, it's like Judge Darn says. I think, you know, in summary, our position is like with the state court judges, it all goes back, you know, to a local issue where you take, you know, the Alapaw circuit where there's no state courts. We seem to have a system with prosecutors and probate courts where we have minimum transfers. Superior Court seems to be working good. Then just our north, you have the Tifton circuit where I think you have 4 out of 5 counties have a state court. A circuit-wide state court may benefit them where it may not benefit the Alapaw circuit. There's more larger cities in that, you know, obviously bigger budgets that the county can fluctuate with, and already an existing structure in place.
I'm sorry, I just have to get clarification on one thing, and that is where you have a county, the jury trial question, as to who can handle that. The probate court cannot necessarily handle that unless the probate court judge obviously is an attorney and is designated as an assisting Superior Court judge by the Superior Court, correct?
Well, there has been Article 6 court for a probate court to have a jury trial, and in my knowledge, none of the Article 6 courts in the state have a traffic or misdemeanor jurisdiction.
You could conceptually have a probate judge that has the same requirements, meets the same requirements as a Superior Court judge, and then they could be designated as a Superior Court judge and do it. But that would be the only way they could impanel a jury, was it had to be a lawyer that meets the requirements to be a Superior Court judge.
Right. Right. Oh, yeah. I mean, otherwise qualified. I hope that's a given. Otherwise qualified.
I think the other contemplation is that a Superior Court could designate a probate already established that the jury trials are very, very rare.
But the Superior Court is not, please correct me, my understanding is the Superior Court's not actually handling that traffic calendar. They're handling the jury trial because they have to. There's no one else to do it. But do they actually handle the traffic calendar itself? Everybody who's guilty get up and come on over here?
So here's what happens.
No.
The defendant is in probate court and they say, I want a jury trial. It gets transferred to Superior.
Right.
So there's 15 cases on the calendar that said they wanted a jury trial. You have the calendar call, the probate court judge comes in and assists, and those cases, 99% of them are going to get resolved short of trial, even though they said they wanted a jury
Okay,
trial.
that's the clarification that I needed. Provided the probate court is otherwise, provided the probate court judge obviously is otherwise qualified.
Yeah, in
Okay.
our circuit, we have several municipal courts, obviously, again, interstate county, who do not have prosecutors in their municipal courts. And obviously, I've learned that before I had a prosecutor, that does create a higher demand for those jury trials. Again, in name only, a lot of times, to my knowledge, in my 4 years in Cook County, I do not know of our Superior Court ever conducting a jury trial on a non-arrestable traffic offense.
Thank you, Mr. Chairman.
Any other questions? Thanks, Chase. Appreciate your testimony today. Well, Judge Jackson, you waited a long time, and we appreciate that.
Let me first say that Judge Wickham is presiding right now. He is the president of our Council of Municipal Court Judges, and he wants me to relate the message that the Council of Municipal Court Judges have a continued commitment to working with the Governor's Office, the Chief Justice, the various councils of courts, and the AOC, trying to improve the system. And I would echo that this reclassification discussion has brought a lot of good communication across lines. We do stress our support of the state court proposal as a good starting point. Melding the state court and our proposal, we think, is the best option of going forward. We do like the idea of probation and training reforms and professionalism reforms. I would point out that there are 7 existing misdemeanors right now for which they are misdemeanors and there is no jail time. The adult and child seatbelt, the HOV hot lanes, the open container, the texting, and the move over. So if you're going to start somewhere, you've got 7 criminal offenses right now that you can never go to jail. I guess if you stubbornly and willfully refuse to pay a fine that you're otherwise capable of paying, you might go to jail that way. But we do have those to begin with. You have our proposal. Yes, there is some debate.
Excuse me. This is what Judge Jackson's referring to.
Many believe that any misdemeanor, whether there's jail time or not, requires a jury trial. That's how you get a jury trial on a seatbelt case. I personally, as a judge, believe in that. If you were to create a new type of criminal offense, and there's some debate whether that has to be constitutional or not, as a, quote, violation, and make it a 6-month violation, there's less debate that 6 months, at least under the federal constitution, would not require a jury trial. Again, the state court constitution may provide more. But if you can overcome that, obviously you've got 7 right now that have no jail time. That might be a good start, and it may be best to crawl before we walk, much less run. Someone did remark, is this a solution in search of a problem? Sometimes the answer may be to do nothing. We have a proposal we think that goes the other way, but as we've heard from the beginning, this thing has many moving parts. To address some of the remarks earlier with respect to surcharges, I believe there was a 2008 legislative study committee that looked at that, and that $100 fine is actually $148. If you get marijuana, the $100 fine is over $200. The surcharges are greater than the amount of the fines, and that committee looked at that. And we all know that these surcharges, for the most part, are not constitutionally separated funds. The last time I looked for the Joshua's training in high school, they collected $30 million, spent $22. The other $8 million went into the state general fund. And all of us sitting at this table, we don't look at revenue as the reason for a court or prosecution. It's unconstitutional. But it's still there. And you still need to understand that if you make these things civil, you will eliminate all the surcharges, and that will have a revenue effect. And that's a political question that you as representatives have to decide for your collective selves. I do know that and the minutes of the last Chief Justice's meeting, they pretty much approved the idea of state income tax interception to collect seriously delinquent fines. It will work for some people. There's some people who have no income or who file no tax return. But we have looked with the Association of County Commissioners. We've got some legislation we're looking at. Most states, the cost of setting this up is somewhere between $5 and $15. The last draft I looked at had a ceiling of up to $20, which the offender would pay. And it's user optional, so it's not it's not an unfunded mandate. And the numbers in the 12 states that I've seen, last fiscal year, Wisconsin collected almost $21 million in unpaid fines. Arizona over $18.5 million. California over $10 million. The first year, Missouri tried it over almost $1.5 million. Every state sees interception of income tax refunds to collect delinquent fines as an absolutely fiscal home run. And the people who owe the money, they pay for that. It's not a financial burden on any court, and if we make it user optional, it will be a success. And the general consensus is that's something that should come out. That's really not a part of reclassification,
No, it's not.
but it's there. Because if you look at reclassification, make it civil, you're going to have fine problems. You're going to have probation problems. People need the time to pay. My personal experience is a little different because Atlanta at one time had a limited state court of jurisdiction. Mr. Drolet was our prosecutor, where we had both jury and non-jury trials simultaneously. In our consolidation, we eliminated that. We've got 8 judges down from 16. We're authorized at 10. In our jurisdiction, if I were to sit and go over to Superior Court and handle a jury minor traffic offense, which we used to do, there's nobody to take over my 250 cases a day. In a rural county where the courts meet once or twice a month, yeah, that could work. So again, actual results may vary because we're on a very different setting than other areas. But this morning I bound over half a dozen cases to state court. All of them were suspended licenses, not minor traffic. But we do have the jury trial on a speeding case. We do have the jury trial. And yet 86 and a 70 is a super speeder. If you work for UPS, you do need a jury trial. You could lose your job if you lose that case. So there are factors, and we do have the Freemason, freeland people who don't think the law applies to them, and the people, the flag fringers. I've had to deal with those too. And there are times, and this for me is 12 years, I can count on less than 2 hands the number of people who have actually gone to jail on what many would think would be a minor traffic offense. But when you have 29 speeding tickets, something's got to give. When you have a man, I had last month a 19-year-old on his 4th ticket. I took his license away, and that night he went out and drove again. He spent a weekend in jail. It does happen, and it is a pothole along the road. So we need that flexibility that Judge Darden and our prosecutors talked about. But we do have a proposal. If you want to go reclassification, 2 tiers on a standalone basis. Of course, if they're connected with another offense, we think that it would be otherwise. But again, that's for your collective decision making. But the conditions in Atlanta are very different than Cook County, are very different than Hall County, are not a whole lot different than Cobb County, except for volume. We're running 300,000 cases a year through our court. But I'll be glad to answer questions and try to answer them as our President Whitman would want me to. But it is a very complicated system with many moving parts.
Okay. Judge, thank you. I appreciate your testimony. I appreciate the panel's testimony on this. This is, you know, what's great, I guess, from my perspective, is to hear that you are making some progress on a number of fronts just by the ability to sit down and talk about how better to do this, and there's a best practices type of some ideas coming out of this that may enhance your ability to do this. I really would like, when you guys get back together again, I'd like some reconciliation of what these Tier 1, Tier 2, as opposed to the, the other recommendations are here and the overlap and so on. I'm not as familiar with these things as I should be probably, but the fact of the matter is it is a little confusing. Let's see, any other questions or discussion concerning this issue? Well, I appreciate your time again today, and you guys are going to go back and work on this a little bit more, and I don't necessarily sense that there's going to be a lot of change here from what I've heard. But I'm hopeful that the data and the reconciliation data will make a more quantifiable case. I mean, what I'm hearing from you is anecdotally, this is what I see, one case out of gazillions and so on, or bound over for trial and things like this. I mean, all this sort of stuff is, to me, anecdotal. I'm much more a numbers guy, and that's why we put it back on the AOC to try and weld these numbers together and see if we're really in the position we think we are with regard to cost, timing, efficiency, and effectiveness of the judicial system and curbing these offenses. Judge Jackson?
Let me comment that before our courts were consolidated, and this may be a workable solution in places like Cobb or Columbus or Augusta or Atlanta, we had a limited court, a limited state court jurisdiction, which was traffic only, and any other misdemeanor arising out of a traffic offense. For example, if you were caught with a gun improperly stored or possession of stolen merchandise, at that time less than 300. So it was a ride-along offense. And when somebody wanted a jury, we just turned to the clerk and say, send up a jury. And we handled it right then and there. And of course, immediately that jury demand was withdrawn. But that may be a way to solve the problem, at least in the major cities, where we won't have these transfer cases over to state court. We're sending what, 1,400 to 1,500. There's your numbers on non-minor offenses, and it may very well be they've run out of time to continue in municipal court. In my particular division, we'll give them as much time as we can, but there is a limit to everything. That may be it.
Everybody agree that sounds like a reasonable approach?
We'd have to hash that out.
Yeah.
The devil's in the details.
Further information, in other words, right? Further information.
And it may not be that ever happens anymore. That may just be gone by the boards, and so be it.
All right, gentlemen, thank you, and ladies, thank you. We appreciate lady. Thank you. Yeah. Okay. I think, do we all know where we're going here at this point in time with our with the process?
And what we'll do is meld the proposals together and come up with what we can to be as near a consensus as we can.
Okay.
The idea that non-movement violations would seem to be the focus for any reclassification, be it, but at that point also marry up the data analysis with that.
I think that's where we're at. You agree? Okay. All right. Thanks an awful lot. We appreciate it. We are scheduled to go till 1 o'clock, and what we have left for last is a continuation of the discussion that we had last time, which is not the reclassification discussion. It's everything else. And let me just try and summarize where we are on this. For purposes of refreshing the committee's memory, we asked Terry Long, Legislative Counsel, to consider the thoughts that we had from last time, and look at the possibility of how they would flesh out from the standpoint of a legislative solution to some of them. And from that standpoint, Terry does have a draft bill that should be on your desk at this point in time. It's the only one you've got, and this is it. And I asked Terry to briefly kind of go over the concept behind what she's drafted. And what it does not include are some other things that I think I mentioned to you in my email that we wanted to talk about, and that there were some other things contained in the schools, the private school issues, which had to do with the fee increases and the 120 risk reduction program. But you covered that in what you wrote up, I think, Terry, did you not? I think you did.
Chairman, I did not include the fee increase.
No. I'm talking about the 120 days. I think you did.
Initiating the course within the
Yeah,
120
right.
days of probation.
Which was what was requested, I believe. Okay. Why don't we, instead of me jumping around here, why don't we just take it in order and go through this set of recommendations. These are not Terry's recommendations. These are kind of consensus thoughts that came up in a discussion about this by the committee members. So you want to take it from there, Terry, or is that, am I putting you in hot water here?
I'll be glad to
Hold on a second. What number is that down there?
14.
Okay, go ahead.
Yes, you were handed 2 copies, I believe, and it is the legal size, just to make sure you don't have anything cut off. I believe the original copy that you were given, were those, I don't know if those were picked up, but we're reading from the legal size document. The provisions included in here, I attempted to include those provisions where there was the most consensus, I felt, but not necessarily a majority consensus. Also, I note that this is a draft and will have to be fleshed out as far as cross-references and that sort of thing. As most bills, this bill is put in order based on title, chapter, and section. There's no particular order or reason why one section's first and over another section. The first section, section 1, is pretty straightforward as it's drafted. It prohibits any pretrial dismissal of a traffic offense where that dismissal is based on the offender's attendance in a driver improvement clinic or defensive driving clinic or DUI alcohol awareness type program where that program has not been certified or licensed by the Department of Driver Services.
Let me stop. What I think would be good to do, if there's any comments on each one of these by any of the committee members, or I would entertain any comments by members of the audience here today that feel like they've got something to contribute to this. Let's do it that way, and then we'll just see if we can move through it that way. Go ahead. Are there any? All this section really does is say that you before you dismiss, you've got to and if there's a course required, it's got to be an approved course by the Department of Driver Services. Is that right?
That's correct.
Okay. All right. And it lists them in terms of the driver improvement clinics, the drug, alcohol awareness, DUI, alcohol risk reduction programs. All right.
Yes,
Okay.
Mr. Chairman.
Anybody out there want to comment on any of that? You must be hungry. Oh, I'm sorry. We don't allow prosecuting attorneys to do anything about this. I think all this is saying is that if the dismissal is based in whole or in part on the accused participation and completion of a driver, and it lists the programs, which are all the DDS programs. In other words, you can't assign somebody to a program that's and dismiss the case that's not that's one of these that's an approved program.
And if I may point out, Mr. Chairman, these are UTC offenses. I don't know if that matters, but these are UTC offenses.
Mr. Chairman.
Thank you, Mr. Chairman. I think that what we're going, this is a conceptual conversation going to intent. My understanding of the intent of where we're going, and the devil is in the details, and presuming that something like this goes forward, there'll be dozens of sets of eyes that will look at it. But the intent of it, as I understand it, is to prevent Chairman Rice and I from throwing up four walls and calling ourselves a risk reduction program, as opposed to just a certification, verification, credibility mechanism.
And that's the concept behind this, I think. And we obviously don't want to tramp all over your individual capability to adjudicate how a dismissal goes. So.
And we look forward to working with the council and members of the commission.
Good. 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 Well, and we welcome that. I mean, that would be certainly something we'd want to do. Terry, you want to? Oh, Skin? Sure. Yeah. Yeah, as Chairman Golick points out, you want to make sure we do the appropriate carve-outs for, to allow the latitude of the court to be able to address the issue that they're trying to solve. All we're trying to do is to make sure we don't have bandit programs out there for which, you're really not getting the bang for the buck, and it's all about the dollars. All right? Okay. And by the way, therein lies the risk of having a draft piece of legislation exposed for public comment. And we'll try a couple more of these things, and we'll see if we can move ahead. Terry, why don't you go ahead on the next one?
Section 2 is intended to clarify the offense of driving without a license. I certainly welcome the solicitor's input, Solicitor Association's input on this particular issue. As the statute is presently worded, there has been expressed some concern whether any prosecution can be made for certain types of offenses. There is an attempt just merely not to change the offense, but to clarify these provisions for when a person is not guilty. If their license is expired and they obtain a new license, then they would not be guilty of any offense. If their license had never been obtained, but they're driving without a license, and they go and get one before they go to court, then it's a misdemeanor offense. If they're driving without proof of a valid license, then that's handled in a different code section. If there is an individual that never obtained a license and does not obtain a license prior to court, then they are handled under a different code section already, which is a more strenuous penalty. But again, the details of something of this nature certainly needs prosecutors' eyes.
Sure.
Mm-hmm.
Well, these issues of driving without a license from any variety of sources are a constant concern, and all we're trying to do is to make sure that we're clarifying this so that we know what the possible penalties are for it.
Section.
Yeah, hold on a second,
I'm
Terry.
sorry.
Chairman Golick.
Mr. Chairman, we may just want Ms. Long to go ahead and go through it. Do you want to go ahead and talk about potential issues with it, or would you prefer to sort of get it out to members as to here's what we're looking at, and then we can talk offline about issues in the draft? Or I want to be respectful of time.
Okay. All right. That sounds like, to me, you think it would be more expeditious to consider this offline.
No, that's not what I'm saying. I just wasn't sure if you wanted us to go ahead and express a concern now about what we see, or would it just be better to go and get it out there, and then we can talk about concerns later. If you want to talk about it now, then I've got a concern, but I don't want to do that unless your schedule allows for it.
Okay. Let me suspend for a second and make sure that I see what we got here.
And we're not running up to the Rules Committee, tomorrow or anything like that. So it's it can certainly wait. Put it that way.
Well, being judicious of the committee's time, I think that probably what we ought to do is to continue this offline and take a look at these changes, which we haven't considered together as a committee yet, and move ahead. And that would probably, the only one that I really want to spend any more time on is the DUI interlock issue. And if you could just explain what you want.
Covered primarily in Section 4 as well as Section 5. Basically, the interlock would be required for the driving permit on the first offense after 120 days, I believe. If the individual offender had an alcohol concentration at the time of the offense exceeding or 0.15 or more grams. As it's written now, it would be required for a driving permit on a first offense if the concentration was 0.15 or greater. Correct.
Unless the additional requirement is waived by court order due to financial hardship, I think is what the caveat is.
Yes, Mr. Chairman, that just mirrors the permit language already in the code section. And Section 3 is Section 3 is raising the or lowering, the passenger occupancy for individual drivers holding a Class D license. Class D license holders would now only be permitted at any point after the first 6 months to have one passenger who is a non-immediate family member.
Okay.
And that is covered in Section 3.
And I think Governor's Office of Highway Safety, Harris, you commented on that. We've got data on that I think the committee is fairly supportive of at this point in time.
May I ask a question to that,
sure.
Mr. Chairman?
Oops, sorry.
That's all right. I wanted to ask Mr. Blackwood about that, and I've seen the same data that you have, both from NCSL, and by the way, thank you for what you do for the administration. I've seen the NCSL data. I've seen the IIHS data. I see a very clear empirical connection. I also look at the fact that our neighboring states have lower other teenager thresholds, really just at 1, which is what this draft contemplates, and I think would going forward. Am I safe to say the administration would be supportive of that? And I didn't hear your comments last time, so that's why I'm asking you the question. Thank you. And just to make sure it's clear, you may already be aware, but our neighboring states, some of our neighboring states, I believe, have a threshold of 1, and no more than 1, whereas we're at 3, and the empirical difference is pretty stark in terms of lowering that number and eliminating a certain number of teenage deaths on an annual basis. So I look forward, if I could be of any assistance to the administration in that, because it's something I feel passionately about. Okay. Well, thank you, and just at the appropriate time if you have any questions.
Any other questions or comments? All right. That basically covers it, doesn't it, Terry? Basically the things that we talked about, I think.
There are other sections.
I think those were the salient ones that we commented on, though, weren't they?
The primary ones. Section 6 modifies the provision requiring fingerprints for operators of driver improvement clinics, so that once an applicant has a set of fingerprints available to the department, that they don't have to continue to get additional fingerprints. Section 7 requires on a DUI offense that the DUI alcohol or drug use risk reduction program be conducted within the first 120 days in order to allow the court an opportunity during the period of probation to make sure that that happens if it doesn't happen within the 120 days. And then the last provision, which obviously needs a lot of fleshing out, is the taxpayer refund provision, where unpaid fines, fees, and court costs could be automatically deducted from taxpayer refunds.
Judge Jackson. Well, a draft is a draft, and that it's meant to encourage participation here. So I think that's what we want. No, I think that would be. I think it's part of the the Title 40 comprehensive study committee work, if it's can be defined and and a solution found to it.
There was some discussion about if you're under 21, because we have so many mandatory suspensions, that under 21 would not be allowed to use the PDD, so that they couldn't pay that $85 an hour speeding ticket without mom and dad knowing, and all of a sudden their license is suspended. Whether under 18 is paying your stop sign tickets and their license gets suspended. The problem why in our city of Atlanta, we designed our CDD so we can't do it under 21. We're tired of getting those motions set aside and going back over. So that was some of the discussion that the stakeholders were talking about with the Chief Justice, that maybe that's something to look at, and also the language, I think, might be very archaic too, if it's in that.
Traffic violations under those authorized back in the 60s, whether or not we jurisdiction courts about review traffic violations or a lot of administrative process in the county. Some have a short process, obviously we have judges law enforcement for holding anything accountable or responsibility for direct information. Looking at ways to modernize that within the context of our traffic policy. It is a rapid message there to some of the stakeholders. So what we're trying to do is follow exactly the remarks you guys made. Fully fleshed out.
We have law that talks about keeping records on paper index cards. It actually says that.
All right.
It hasn't been looked at in, 50 years?
Well, I think the committee would, if you can, all the committee's responsible for is recommendations, and the legislation that follows recommendations or may not follow recommendations is still to be seen, and so that'll start to appear as we move into the session. and go through the normal committee process and things like that. But from a study standpoint, if you do have, and could show cause why this should be changed, then I think it would be appropriate to look at that from a recommendation standpoint. But it doesn't have to be solved necessarily. It needs to be considered and said, we need raised, and we need to look at that within the structure of our committee. Or if you do have a solution, then all I'm telling you is you don't have to go all the way to solving the problem. It's kind of like we've done with the reclassification. We've moved to solving the problem, but you don't have to do it with that, I don't think. Is it clear enough or muddy enough? Or what? Okay. All right. Both. Okay. I'm never going to appear in your court, Judge, I'll tell you. Well, with that, the committee is going to adjourn to the Appropriations Conference Room, where we'll have some lunch, and we'll thank you all for coming today and for your valuable time. I really appreciate this. Hopefully we're making progress. Thank you.